Welcome to the inaugural episode of Husch Blackwell's newest podcast on the False Claims Act. I'm your host, Jonathan Porter. I'm a partner in Husch Blackwell's White Collar Group. I'm based in Georgia, and I'm a former federal prosecutor, having dealt with the False Claims Act from within the Justice Department. Now I help guide clients through federal investigations, including investigations brought under the False Claims Act. I'm very excited to be hosting this new podcast. Why are we doing this new podcast? It's because the False Claims Act is a big challenge facing many clients in several of the industry groups that Husch Blackwell serves. Healthcare, defense contractors, financial institutions receiving federal backing, companies importing goods, universities receiving grants, ag companies with federal insurance. Any industry doing business with the government should have an eye on the False Claims Act because the False Claims Act is serious business. Last month, the Justice Department released its annual report on its False Claims Act results, and that report shows how important this work is. There were $2.7 billion worth of FCA settlements and judgments last year, and perhaps more important, DOJ announced a record number of new FCA matters, new investigations. The False Claims Act is a serious and complex area of the law, and it's something that Husch Blackwell strives to guide clients through. And so we have created this podcast, the first of its kind, to talk through some of the biggest issues in False Claims Act enforcement. Our goal here is to make this podcast informative, practical, and also a little entertaining. We want to give you a glimpse into this complex world. This is our first episode, and today's topic is whistleblowers. Joining us to talk about whistleblowers is Jody Rudman, who chairs Husch Blackwell's White Collar Practice Group and spearheads the firm's False Claims Act working group. Jody is a former federal prosecutor in the Northern District of Texas, and now at Husch Blackwell, she helps guide clients through federal investigations. Jody is a veteran trial lawyer, which is a bit of an endangered species in the legal world today. And Jody represents clients from investigation through appeals, including advocacy before the United States Supreme Court. Jody, thanks for being this podcast's very first guest and telling our listeners a little bit about whistleblowers.
Thank you, Jonathan. I'm really thrilled to be here, and thanks for that really great introduction. I kind of want to bottle that up.
Thanks, Jody. So I think, Jody, a lot of people know that the False Claims Act is a law that deters fraud against the federal government, and that there are really big penalties for defrauding the government. I think people know that. But what people may not realize is how central whistleblowers are to the government's anti-fraud plan. So, Jody, give our listeners a bit of an overview of the role that whistleblowers play in the False Claims Act and why people choose to become whistleblowers in the first place.
Yeah, sure. I think it would be difficult to overstate the importance of whistleblowers in the government's mind in the False Claims Act world. So let's start here, which is that the government, specifically the Department of Justice, can, of course, initiate its very own investigations and litigation in the False Claims Act space. But even so, the majority of False Claims Act cases are actually brought to the Department of Justice by whistleblowers. And in that context, whistleblowers have a special name. They're called relators, although it's perfectly okay to also refer to them as whistleblowers. In litigation, they're called relators. And so if there are any lawyers out there or those who are familiar with case names, you might see United States ex rel and then somebody's last name. And that indicates that this is a relator-driven controversy. And relators, whistleblowers in the False Claims Act world, file lawsuits that are called qui tam lawsuits. Different parts of the country will actually pronounce that differently. It's two Latin words, so you might have heard of qui tam or qui tam. In any event, here we call them qui tam. And those lawsuits are filed by these whistleblowers or relators under seal. And then copies are given to the Department of Justice. And then the DOJ actually investigates them without knowledge of the companies or the individuals who are alleged in the lawsuit to have committed the fraud. So that's kind of an overview of the process. The why of it was kind of the second part of your question. So let me get to that. Often whistleblowers, come forward because they, feel that it's a sense of civic duty, to bring forward allegations of fraud against the government. But I'd say that a lot of the motivation is often monetary because, as it turns out, whistleblowers get a percentage of the dollars that are recovered. And that is whether through settlement or whether through a litigation, judgment, verdict, and award. The qui tam relator will get anywhere from 15 to 30% of what the DOJ collects and attorney's fees and costs. And that percentage range will ultimately come down to an assessment of factors, including how helpful was this whistleblower to the DOJ. You might be asking why? Why did Congress, in creating this statute, give whistleblowers a share of recovery? And that was essentially to incentivize them in recognition that whistleblowers are really in the best position to identify fraud. So, Jonathan, I can kind of go on and give you a, sort of a very specific example of that for the listeners. And for that, I don't want to use any names, so I'll just stay real general. But to give you a sense of kind of the inside view that the government wants to encourage in incentivizing whistleblowers financially, there's a matter not too long ago wherein a university was alleged to have committed research fraud. And, the question is, would the government have known about it but for a whistleblower coming forward? And the answer is maybe not, because in that particular instance, you have somebody who saw, as far as he alleged, that a peer in his same position was faking tests and results in a matter that was funded by federal grants, and that no one within the employer had done anything about it. And so he filed this qui tam, this whistleblower action. And ultimately, the entity settled with the Department of Justice for a very, very significant sum of money. It was over $100 million. And in that instance, this peer, this whistleblower, got $33 million of that. So the inside knowledge and the financial incentive, kind of come sort of together in that very specific example to indicate why this is so important to Congress to write in that these folks get an incentive fee.
Yeah, I think that's right, Jody. I think what Congress had in mind was incentivizing someone who has unique insights, someone who, through their position within a company, knows that there's some fraud going on. Because especially with research fraud, the way it works, there's not some NIH staffer who's sitting in on this research who's able to tell if things are being faked. It's actually really hard to figure out if things are being faked. And so it makes sense to sort of reward people to come forward. And in that example, in that university example, the whistleblower was an employee, it was an insider who went through the proper internal channels, tried to go through the compliance program and then was ignored. I think that's the fact pattern that most people expect when thinking of whistleblowers. But Jody, for those of us who defend False Claims Act investigations a lot, we're seeing more and more cases of other types of whistleblowers, non-employee whistleblowers. Jody, who exactly can file these qui tams and become a whistleblower?
Yeah, that's exactly right. You kind of see it coming from all sides, Jonathan. And part of the reason for that is that the statute itself really does not contain any linguistic limit on who can serve as a whistleblower. So you don't have to have an insider. You don't have to have an employee who can serve as a qui tam relator. In the healthcare space, for example, sometimes we've seen whistleblowers who are actually patients or former patients of the entity that they're accusing of False Claims Act violations. We've seen competitors who file qui tam lawsuits against companies that they believe are bending the rules. We've seen qui tam lawsuits that are brought by compliance consultants who were actually brought in by a company to examine areas of alleged noncompliance. And then these compliance consultants turn around and file qui tam lawsuits after their advice was ignored or flouted or not taken. And then this one is really interesting, and I think very sort of, 2024 and forward. And that is that recently the Department of Justice announced a settlement in a qui tam matter that was initiated by, are you ready, a data mining company. So this data mining company actually had no affiliation or relationship with the company that it was accusing of the False Claims Act violation. It just took publicly available data that it had mined, and then it used that to allege fraud against a roofing company that it said had gotten a federal loan through improper means. So they're coming from all sides. And as the False Claims Act and False Claims Act litigation and then the space really gets bigger and bigger, we are seeing more creative qui tam relators, often in ways, I think, Jonathan, that Congress may not have anticipated so long ago when the statute was written and all the years that it's been revised. I do want to say, because that sounds a little doomy and gloomy maybe, but I do want to say there are constraints, right? It may not be necessarily embedded within the words of the statute, but there are case law created constraints on people just coming forward right, left, and center and alleging qui tams out of nowhere, right? And these case law constraints really do attempt to cabin the misuse of the False Claims Act by people who really don't know what they're alleging or really don't have a good faith basis, or people who take public information and just kind of cook it up into a fraud theory. And I think if I'm sort of looking in a crystal ball, that those restraints cabining the sort of runaway aspect of qui tam relatorship is probably going to be something we're going to see more of in the next few years.
Yeah, I think that's exactly right, Jody. Not only are there protections on the qui tam side, you're actually starting to see some companies that are being accused of fraud pushing back against relators who have bad intentions through other actions. Our group wrote last year about a case in West Virginia where this health system was sued in a qui tam, alleged to have committed fraud. But then when you peek behind how that qui tam got filed, you found out that it was actually sort of instigated by a competing health system's general counsel. And then that general counsel ended up spreading rumors of the federal investigation that he caused through getting his friends to file this qui tam, used that to malign the health system with physicians and other people who could have been referral sources. What ended up happening was the maligned health system, the health system that got investigated, sued the general counsel and a few other of the relators and were successful, as I understand. They were successful in suing for malicious prosecution. So there are these checks that I think those of us who practice in this space have to be thinking about and sort of getting aggressive, because there are more and more unique ways, creative ways that people are filing these qui tams. There's got to be some sort of a pushback. And so it's important for us to figure out on the defense side how to push back when there's a wrongful use of one of these qui tam vehicles. So, Jody, I think those situations aside, is it safe to say that employees, though, are the most likely whistleblowers? And if so, why is that?
The short answer is yes. And for a lot of the reasons we stated earlier, which is that employees really are in the best position to visualize, to assess, to view not only the facts of what's going on, but the very, very important element of the company's knowledge. Because a False Claims Act case, in order to be proven, in order to be successful, must have as a constituent element what we call scienter, or the company's knowledge about what was going on in the alleged fraudulent nature of what was going on. And so employees are really in the best position to say, this is what my employer knew, or this is what they said, or this is how I communicated it and nobody did anything about it, or they blew me off, or whatever. before the False Claims Act itself, remedies would have really been breach of contract type of remedies. We contracted with you, this federal contractor, to perform these duties, and you didn't do them, and you breached your contract, and that's how companies would deal with the government or would deal with one another when they don't do things that are expected of them. But the government's ability to go from a simple breach of contract into the False Claims Act space with all of the attendant penalties and the significant trebling of damages and all of the very hard hammers of consequence takes more than that, right? And it takes this scienter, this level of knowledge about the alleged wrongdoing. So I'll give you an example of that, of why it is that employees are really in the best place to know that and to get over the hump, that scienter, that knowledge hump. And this example comes to us from Louisiana, where we have a recent, actually turned into a criminal prosecution, but it was a hospice owner in Louisiana, and an employee had filed a QTAM False Claims Act lawsuit. Let me just take a minute here and say the False Claims Act is a civil statute. And so this matter that I'm talking about turned into a criminal prosecution. But people should just understand that an FCA case in and of itself, all by itself, is a civil matter. In any event, in that situation, this employee did file a civil QTAM lawsuit alleging fraud, and that QTAM lawsuit stayed under seal. We'll talk about the seal, I think, maybe in just a couple minutes. That's an important part of all of this. And then the whistleblower, the employees, stayed on as an employee with this hospice in Louisiana for years. Why? Because the employer didn't know that he or she had blown the whistle because the False Claims Act lawsuit was under seal. And while employed, this employee had access to documents and conversations and other matters that it could alert the Department of Justice to. And the hospice owner only found out about the existence of all of this when the FBI showed up and came knocking. And at that point, this matter turned into a criminal matter. The hospice owner was indicted. Ultimately, he or she was convicted. And all of this begins with the employee and the access and the knowledge that this employee has that creates this, very significant result.
Yeah. And Jody, I think in a future episode, we're going to talk about ways to manage whistleblower risk among federal employees. I think in a future episode, we might also want to talk about how these False Claims Act investigations can turn into criminal investigations. Those are called parallel proceedings. I think that's a pretty critical component. That's a little teaser for the listeners. Keep listening and we'll keep bringing you interesting content. On how to manage whistleblower risk among your current employees, I think the short answer is have a robust compliance program, because I think a lot of people, they think about fixing it internally before they file these QTAMs. And so a robust compliance program is one piece. The other key piece, let me just make sure we're making this. If you think an employee is a whistleblower, do not retaliate against him or her. There's independent problems that creates. And so, again, we're going to talk about that in a future episode. But Jody, I'm interested, when DOJ is investigating a QTAM, you talked about the seal. Why don't you tell people about the seal? Does that seal prevent DOJ from just coming out and telling the target of their investigation that there's a sealed QTAM? Do they tell the target who the whistleblower is? How does all this work?
Yeah. No, the DOJ, nobody can reveal the contents of a sealed QTAM lawsuit, including who the relator or relators plural is or are. So the seal is a court-ordered seal. And when the QTAM lawsuit is filed, it is placed under seal, and it remains under seal for a long time, during which the DOJ is conducting its own investigation to decide whether to intervene and get involved in the lawsuit. A violation of the seal is actually contempt of court because you are violating the court's ordered seal. So that's a big no-no. That said, Jonathan, those of us in the defense space are well positioned to recognize when we kind of know this investigation is being driven by a relator qui tam lawsuit. The DOJ, of course, will not confirm, nor should we put them in the position of even asking. And a lot of times, clients who believe that there's a sealed qui tam will kind of try to figure out, I wonder who the relator is. But you'll never have any confirmation of that until such time as the seal is lifted and the lawsuit becomes, public record. And there is a when, that happens. Often once the DOJ makes its decision on intervention, whether that's we are going to intervene or whether we're not going to intervene, then there's a court order lifting the seal and suddenly the thing becomes public. Or if DOJ decides to get involved in order to try to negotiate a settlement, then those discussions will often lead to a revelation of the existence of a qui tam lawsuit and ultimately the existence of the relator and his or her counsel.
Exactly. So, Jody, I think what's interesting is it gets really complex there towards the end. If there's going to be a settlement, there are exactly what you said. There are steps to be taken where you can loop in. All of a sudden, the defendant gets notice of it because there's a lot of things to be settled with that. But Jody, our group is fortunate to represent a lot of, good clients who convince the Justice Department that they have not violated the False Claims Act. For clients where DOJ wants to close their investigation, not settle anything, they don't want to take the qui tam forward. What exactly happens to the whistleblowers' qui tam?
Yeah, when the DOJ makes a decision not to intervene, of course, the matter is unsealed, and very often you see relators who just decide, I don't want to do this on my own. I'm just going to go ahead and exit stage left, and that's kind of the end of that. But there are relators and their counsel who are in it for the long haul and will elect to go ahead and litigate the case standing in the shoes of the government. And actually, a lot of declinations by the Department of Justice not to intervene come with a caveat that the DOJ may go ahead and intervene sometime at a future date. So there is a reservation of that right. And the DOJ actually can step in a while later and seek to dismiss the case. This was really an interesting litigation event. There was a decision by the United States Supreme Court in the last term all about the government's dismissal right. So if the relator standing in the shoes of the government decides to go ahead and proceed, notwithstanding DOJ not intervening, there are still ways that the government, babysits the case. It is still the government's claim, so to speak. And the government can still remain involved, even from the sidelines. But a relator-driven qui tam lawsuit certainly is an option for a whistleblower. It's a long slog most of the time. These cases take a long time to litigate. They're very expensive to litigate. So you have to have a relator and a lawyer, who are really in it for the long haul for that to happen.
Yeah, Jody, I think what's interesting, and you mentioned the case the Supreme Court case last term that spoke to the government's dismissal power. That was the Polanski case. Sort of a side note that maybe we'll bring up in a future episode was Justice Thomas's dissent that said that he's unsure that these qui tams are constitutional in the first place. I think that is an underdeveloped theory that I think he's onto something there that would certainly rock this entire industry. But one of the things that's interesting, in addition to the DOJ having the power to affirmatively dismiss, which Polanski made clear, there's also the possibility of the Justice Department settling. They can, exactly what you said, it's always going to be the government's claim at core. And so the Justice Department can jump in later and settle a case over the relator's objection. I think you see that every now and then when the government realizes, okay, this whistleblowers has a little kernel that is potentially true and the rest of it is less true. And so they'll jump in and they'll settle on that little, kernel of truth, and the whole thing goes away. That's something that I think experienced False Claims Act attorneys know sort of when to ask for that and how to go about obtaining that. because that's a big win for a client if they can avoid a trial, settle on that little tiny bit and make the whole key tam go away. And so, Jody, I guess what sort of final question for you, for companies that are doing business with the government, if they're concerned about federal investigations, if they're concerned about whistleblowers, compliance programs, what should those companies look for in selecting attorneys to help them with all of these very complex issues?
Yeah, that's a great question. This is an extraordinarily complex area of the law and always emerging. Almost every term the Supreme Court either grants cert and decides a False Claims Act issue or is given the opportunity to and is faced with a circuit split on important and thorny False Claims Act issues. So I think it's important to work with counsel who understand the space really and who keep abreast of developments in the space because they are always happening. It's a very dynamic environment and not at all, a static one. The other thing I would say is that, although a False Claims Act defendant is in essence adverse to the government, I think good working relationships with the government, which you often see in firms that have, lawyers who used to be with DOJ or who used to, work in the FCA space for the government. I think those relationships are really important. That's not to say that, anybody has any undue or improper influence at all. Not at all. But a deep understanding of how this works and how to get, all of the constituent conversation people at the same conversation table, I think is a really good thing to have. And there are plenty of, fantastic law firms and fantastic and experienced lawyers. I'm fortunate that I think that you are and that we are at Husch Blackwell, but lots of really excellent lawyers and firms in this space. And I think it's a really good idea to align with really qualified counsel. This is not light stuff.
That's exactly right, Jody. And I think that's an important point is the nature of key tams, the nature of the False Claims Act. It's not totally adversarial. Usually if you're doing this right, you've got a good working relationship with the government. I mean, I still believe that the Justice Department wants to get right answers. They're not trying, in normal litigation, you want to win. If you think about your standard plaintiff versus defendant cases, the plaintiff just wants to win. They don't care what the law is. They don't really care a whole lot, whether justice is being done. They want to win their case. And that's totally normal. That's why we have zealous advocates. Here, the government has a vested interest in seeking justice. And that doesn't always mean that they win. That doesn't always mean that they're going to get the maximum value out of every case. And so the working relationship with a good False Claims Act defense lawyer and the government is not adversarial. I remember when I was in AUSA, some people who were defending False Claims Act investigations that I was handling were coming in and treating it like it was adversarial. And that's not the way, I'll just tell you, that's not the way to go about it. There's not always going to be things that you agree on, but you have to always maintain that good relationship because you never know when at the end of this, you're going to ask them to affirmatively dismiss. If you want to settle on that little kernel of truth and get rid of the rest, there are things that you're going to want from the government. And so maintaining good relationships, having that credibility, that's super important in these cases. And I think a lot of people don't realize that is so important, especially in these whistleblower-driven key tams. So, Jody, this is the first of hopefully what will be many episodes about the False Claims Act. Like we said at the top, this is a really important, really growing area of the law. That report that DOJ just came out with, reporting a record number of new investigations. Those are going to be happening in the coming months and coming years. And I'm excited to continue working with you and our great group here at Husch Blackwell that you lead in helping clients through these issues. So this is the first of many. Really looking forward to more discussions on these important False Claims Act issues. But Jody, thanks for being our very first guest, and I hope you'll join us again soon.
Oh, it was my pleasure and honor. Thanks, Jonathan.
All right. Thanks, everyone, for joining us. We'll see you next time.